Welcome back to my series on the law of the TikTok ban. We're doing a deep dive. I've read all 3 briefs. I've read all of the relevant cases. We are talking about all of them together. The goal here is that we will go into January 10th when the Supreme Court is going to hear this oral argument for the TikTok ban. I'm going to stream it live. We're going to be able to listen to that intelligently and know what's going on. Today we're talking about the brief of TikTok Inc. and ByteDance Limited. For an overview of the corporate structure of TikTok Inc. and ByteDance Limited, check out the video that I linked in the caption. Because that corporate structure matters a lot when we get into this brief. For starters, TikTok and ByteDance says that strict scrutiny should apply. Remember a couple of videos ago, we talked about the difference between strict and intermediate scrutiny and how strict scrutiny is the highest level of scrutiny, and that is what ByteDance and TikTok want to apply because it's harder for the government to overcome. Under the strict scrutiny standard, ByteDance and TikTok admit that the government does have a compelling governmental interest in national security. However, they say there is no national security threat here. They say that the government has not met its burden of showing that there is a compelling government interest because there is no evidence that China has ever interfered in TikTok or this app or the algorithm in any way. The government says that there are 2 risks. Those are the 2 compelling governmental interests. 1 is data collection by China. 2 is China's attempt to influence the opinion of the United States by manipulating the content in TikTok via the algorithm. TikTok and ByteDance argue in this portion of the brief that while there is a compelling government interest, it has to be an imminent threat for the national security to be a compelling government interest. They say there is no imminent threat here. The government acknowledges that it lacks specific intelligence showing that the PRC, that's the People's Republic of China, has in the past or now coerced TikTok into manipulating content in the United States. China's never done it. They've never done it in the past and they're not doing it now. That's the position of ByteDance and TikTok. Nor does the government suggest that China plans to do so anytime soon. To the contrary, Congress has allowed the platform to continue operating for 270 days after the act's effective date. The fact that there was 270 days after the act was passed until it went into effect shows that it's not an imminent threat at all. And then as a shot across the bow, TikTok and ByteDance point out that both presidential candidates in our last election heavily used TikTok. How bad of a security risk could it be? ByteDance and TikTok say that the government has failed to look at less restrictive means of restricting the speech to accomplish the same goal. They give 2 examples of less restrictive means. One example is providing a disclosure, just simply providing a disclosure that, hey, there's an offshore company that provides the algorithm for TikTok. So that when consumers consume content or when they post content to TikTok, they're aware that there's a foreign company in the algorithm. Same with data security, that a disclosure could solve the concerns for data security. There's another option they give for a least restrictive means, which is the National Security Agreement. I'm going to do a whole video on the National Security Agreement because it's just too much to include in this, so stay tuned. As to the issue of data security, ByteDance and TikTok maintain what the act does is actually really under-inclusive because it says that there can still be social media platforms out there that allow for user-generated content no matter where they're based or no matter who controls those algorithms that provide for business, travel, and product reviews. And that this act does nothing to control the data security that's happening with those websites. TikTok and ByteDance point out that TikTok Inc. is a United States company with United States rights. That means that it is protected by the First Amendment. They argue that the algorithm itself is speech and the choice of algorithm is speech. Therefore, TikTok US gets to choose whichever algorithm they want, whatever company they want to work with, and that choice in and of itself is speech. They also make a freedom of association argument here. They argue that TikTok US as a US company has the right to associate with whoever they want to, even if that's a foreign company and even if that foreign company has ties to China. TikTok and ByteDance argue that the combination of singling out TikTok for unfavorable treatment, the ban being grossly overbroad to try to prevent covert Chinese manipulation, and the ban being woefully under-inclusive as to data security, leads to the inference that this law was passed for an entirely different reason than what they're saying. The reality is that the government just doesn't like the content that's being generated and boosted by consumers on TikTok. Therefore, they want to ban it. And that, in and of itself, is an unconstitutional ban on speech. Follow along. We have a few more things to cover before we go live on January 10th.